Just waiting for everyone to get connected. Someone's still trying to connect. I believe it's Mr. Eibold. There he is. Okay, everyone's on now. This hearing is being live streamed in order to allow for public access. And this is JLLJ Development LLC and Lansing Future Development 2 LLC versus Quadden Casinos Gaming Authority, docket number 21-189CB. And this was the time set for the defendant to show cause why defendant should not be held in civil contempt of court. And before we proceed, civil contempt of court is punishable by a fine of up to $7,500 per each contumacious act, costs and expenses of proceedings, and damages for injuries resulting from the contempt, including attorney fees. And I'll take appearances for the record, please.
Certainly, Your Honor. Andrew Broder and Michael Perry for the plaintiffs.
Good afternoon, Your Honor.
Jeffrey Rasmussen for Quadden Casinos.
Right, Mr. Broder, are you taking this for the plaintiffs?
I am.
Okay, go ahead.
Thank you, Your Honor. The court knows that on January 28 of this year, Judge Jamo, acting for this court, issued an order directing the defendant to show cause why it should not be held in civil contempt. I represent to Your Honor that the requirements in Judge Jamo's order regarding service on the defendant have been satisfied. This civil contempt proceeding arises out of the defendant's failure to comply with this court's October 27, 2021 discovery order, which the court knows required two things: the payment of $1,500 by one date, and more importantly, the production of the defendant's complete answers and documents by a different date, that date being November 17th. I represent to Your Honor that neither of those things has occurred as of today, and that there is simply no doubt that the discovery order has thus been violated. In an effort to avoid its obligation under that order, the defendant filed a tardy, frivolous appeal with the Michigan Court of Appeals, but that court dismissed the appeal on January 25. And most recently, the defendant sought intervention of the federal court and an injunction from that court holding these proceedings in abeyance, and that effort failed yesterday. It is worth noting that in the federal judge's decision, where she balanced the equities in favor and against an injunction, the federal judge noted the important interest of permitting this state court to actively pursue contempt proceedings against a litigant. And that's why we are here. It is also worth noting, Your Honor, that when a hearing was held by this court on November 17, this court specifically told counsel for the parties that the court's discovery order was not stayed by the appeal that Mr. Rasmussen filed in the Court of Appeals. I submit that he filed that appeal and failed to comply with the court's order, recognizing that risk and recognizing the risk that it posed to his client. Now, MCR 2.313B2D specifically authorizes this court to treat as a contempt of court the failure of a party to obey an order. I note that treating it as a contempt is in addition to any other order that the court might enter in connection with a party's failure to comply with an order. So with that short background, it is clear why we are here today. It is worth noting, Your Honor, that under any standard that the court uses today, and I've read some cases that refer to a preponderance of the evidence and other cases that refer to clear and unambiguous evidence, under any of those standards, the defendant has violated the court's discovery order and is in contempt today. There's simply no doubt about that. In weighing the relief to be granted, Michigan's appellate courts ask or recognize that the court should weigh several factors, including such things as the willful violation of an order or whether it was accidental, the party's history of refusing to comply with discovery requests and orders of the court, the prejudice to the opposing party, whether there is a history of the party engaging in deliberate delay, whether the party has sought to cure the defect in a timely manner, and any other factors deemed appropriate by the court. And I refer the court to Dean versus Tucker, 182 Michigan Appeals 27, a 1990 decision. There is simply no doubt, Your Honor, that the defendant's conduct throughout this litigation justifies a finding against it as to each of those factors I just enumerated. This case is almost 11 months old. The defendant has delayed from almost the beginning of the case. It has filed duplicative motions. It has filed frivolous motions and objections. It has filed defective appeals, such as that in the Court of Appeals. It has chosen what proceedings it will participate in and which it will ignore. And it has failed to comply with several orders of this court. I would note to the court that in addition to violating the contempt order, last week under the court scheduling order, witness lists were due. The defendant didn't file its witness list. So as of today, it violated that order as well. And although that matter is not specifically before Your Honor today, the fact that the defendant has yet again violated an order of the court is simply fodder for the court to consider in determining the appropriate remedy for contempt. Unfortunately, Your Honor, the defendant's attitude and that of its counsel has been arrogance and defiance. I hate to say that, but it's really true. In the comments that Mr. Rasmussen has made to this court, he has stated that he knows better than this court and more than this court what is appropriate. And that attitude has permeated everything the defendant has done in this case. I hope that a finding of contempt with meaningful sanctions will cause this behavior to stop. Frankly, I doubt it will, but that is nevertheless my wish. So let me be specific as to the relief I think is appropriate. There are three components. First, I believe the court should impose a fine of $100 a day, retroactive to November 17, which is the date the discovery responses were due. I would note that the funds that the court ordered under the discovery order were due 2 weeks before, but I'm not asking for that fine to be imposed back to that date. That daily fine should continue until the $1,500 is paid and the discovery responses are received by me. And by the way, that would be, as of today, 84 days. The order should also provide that if those funds and the discovery responses are not received by me within 14 days of today, the court will enter a default against the defendant in this case. And an additional $2,500 should be awarded to cover attorney fees and costs for pursuing this contempt proceeding. Those are the three components that I have. Of course, the court rules permit the court to enter whatever other relief it deems appropriate. That's all I have to say, Your Honor.
Thank you. Mr. Rasmussen?
Thank you, Your Honor. At this point, this court does not have jurisdiction because the defendants have filed an appeal as of right earlier today. And even in their own briefs in this case, the plaintiffs acknowledged that if we have filed an appeal on the June 21st, the first motion to dismiss, if we have filed an appeal on that, then that is an automatic appeal. We have filed an appeal on that. Our appeal on that discusses why the appeal is timely, and it is timely because Mr. Broder was lying to this court in an affidavit. He falsely said he had served the order on the tribe when he had not. And if you haven't served the order on the tribe and the court, or the Kewadin, sorry, if you haven't served the order on Kewadin and the court didn't serve the order on Kewadin, then under the court rules, the time for appeal doesn't start. But more importantly, that is an issue for the appellate court. The appellate court decides those issues. We believe that it will be very bothered by Mr. Broder's action and will say that yes, the appeal is perfectly timely and that this matter is stayed. But again, that is an issue for the appellate court to decide, not this court. Second, the court's rules applicable to this matter require either personal service on the defendants, or potentially the court could, for good cause, say that personal service is not required. In their motion for contempt, the plaintiffs themselves said that personal service was appropriate. But then in their, I believe their proposed order, maybe not, in the order that came out, it did not require personal service. So unless they have personally served, then they are not in compliance with Rule 2.107B, which says that it must be personal service unless the court orders otherwise. And then Rule E, which says that there has to be good cause not to use personal service. So these procedural issues are substantial. It prevents the court from moving forward. Finally, not finally at all, in this particular case, our position is that the court's order to show cause needs to be vacated and the plaintiffs would need to start again, because that too was based upon a false affidavit to this court. And I pointed that out to the plaintiffs, and my understanding is they didn't correct it. They falsely said to this court that they had served the plaintiffs on the 27th. In fact, what they did was they held their motion, didn't serve it on us until they got the order, so that we weren't able to respond to their ex parte motion. I understand that an ex parte motion can be decided ex parte, but that doesn't relieve the plaintiff of their obligation to send it to us and to give us as much possibility to respond as possible. And they didn't do that. And when that was pointed out to them, they didn't correct it with this court. They didn't withdraw it. That is not okay. It is not okay. That's two false affidavits that we're talking about now. In the courts, in the rule, the law in this jurisdiction, this court would next have to determine whether it should decide this motion. And our position is that under the factors this court is to consider, it should not be deciding this motion. This motion and some of the subsequent issues that we're going to be talking about are issues related to this court's actions, including not letting the defendants complete their argument on the motion for contempt before the court ordered it before, or motion for discovery before the court ordered discovery. It cut the plaintiff or the defendants off and did not allow us to even complete our arguments in that particular motion. And that, we believe, is significant in discussing whether there can be any contempt sanctions at this point. So those are the preliminary issues. Then we get into the court still has failed to decide whether or not it has subject matter jurisdiction. It has failed to decide that. And the last time I brought this up to the court cut me off, but I'm going to make the argument anyway, that subject matter jurisdiction has to be decided when it is raised. This court explicitly in its first order to dismiss explicitly said it would not rule on subject matter jurisdiction in that motion. Then, as is permitted by court rules, the defendants filed a second motion to dismiss to cure any alleged procedural defects in the first motion. And that is a commonplace procedure, and this court then again failed to decide that. The court cannot go on to contempt issues unless it first decides whether or not it has subject matter jurisdiction, and it has not done that. Next, if we get into the issues for contempt, there has to be a willful failure. And what we have here and what we have talked about before is that the tribe's laws, which are binding on the reservation and binding on the defendants, provides the process for obtaining documents from the tribe. Title 15 of the Tribal Code is their Freedom of Information Act. It has a process in it. There's also a process for going to a tribal court to get an order. If you want an order for documents on the reservation, that's what you have to do. That is part of the duty that a state owes to a tribe. It can't just impose its view by fiat on the reservation. And so the documents that the plaintiffs are seeking in this case from both the tribe and from Kewadin, if a tribal officer were to release those documents, they would be committing violations of tribal law, including criminal violations of tribal law. I happen to be right now acting as the tribe's prosecutor in other cases in the tribal court. And this would be an open and shut case against a tribal member if they were to release these documents, because it is unlawful under the tribe's laws. And if they want to go and get something requiring a tribe or Kewadin to provide discovery to them from the tribe, from the reservation, they have to get that order from the tribal court. This court doesn't have jurisdiction to order the tribe to take these actions on the reservation. It doesn't have the jurisdiction to order Kewadin to take these actions on the reservation. The tribe's laws also clarify that when we are dealing with a tribal, the tribe, that if we're going to be serving the tribe, it has to be by personal service. So again, plaintiffs haven't validly served the tribe unless they come forward today, and they haven't at this point, with a declaration of personal service, valid personal service, which again, when you're taking an order from this court onto the reservation, they would have to go into the tribal court to do that. They would have to get that order converted into a tribal court order, just as if the tribe came into this jurisdiction and said, I'm going to serve these things, it would have to get that converted into a state court order. That is part of the Supremacy Clause and stems from the Supremacy Clause in the United States Constitution. When Michigan became a state, it disclaimed authority over Indian law, Indian reservations, Indian lands. And what we're seeing in this case is that creates difficulties. So there's no willful violation here, because any violation that they're alleging would also be if the tribe were to do it or Kewadin were to do it, it would be a violation of the tribe's laws. And that needs to be resolved. And the way that the plaintiffs would have to do that is to go into the tribal court and make their argument there. When we're talking about actions on the reservation, the tribe has the jurisdiction, not this court. And that jurisdiction is guaranteed and protected by federal law. And if this court were to issue the order that the plaintiffs are asking for today, then that would just add another cause to the federal court complaint that has already been filed related to this matter. And it would be an easier argument on that issue, because then we are specifically reaching onto the reservation. This court is specifically reaching onto the reservation and ordering the tribe to do things. It already did that. If it were to do that now and use its contempt power to try to enforce that on the reservation, that would be a simple violation of this court's authority and jurisdiction. Finally, plaintiffs have not made any, provided any basis for post-dating the sanctions. If the court were post-dating sanctions, our position is that that would be criminal contempt, because that is not something that at this point can be purged. So when the court issues a civil contempt violation, it can only be forward-looking on that. Plaintiffs asked for $2,500, and as with the last time where they asked for $1,500, they're required to provide proof of that. They didn't meet their burden of proof. He just says he wants $2,500. Last time that was sufficient. He said he wanted $1,500. Court didn't let us respond, and the court granted that. This time, the court needs to consider that issue, that it doesn't have proof. The proof failed. They presented their case, and they failed to prove it. Finally, a contempt case has to be based upon evidence. They have not provided any evidence here today. They only provided argument. So they haven't met their burden of proof on any fact whatsoever. And for that reason, the motion also must be denied. But going back to the start, our view is that plaintiff pursuing this particular contempt action, when there is an appeal of right filed, and it's up to the appellate court to decide whether that is to dismiss that if it chooses to, although I don't think it will. But that appeal of right under their own brief is sufficient to automatically stay this proceeding. That may be frustrating to the court. That may be frustrating to the plaintiffs. It has been frustrating to the tribe and to Powhatan that they're being ordered to provide discovery in a case that this court does not have jurisdiction over, when this court has not determined jurisdiction. The personal attacks by Mr. Broder are simply inappropriate. This is what attorneys do. This is what attorneys for tribes do. We just completed in our office a case that went on for 5 years or more that's very, very similar to this. And we had a state court judge that was issuing orders, and we were saying they were wrong. And we went to the federal court, and it denied our motion. And we went to the 10th Circuit, and we won. And then we went back to the district court, and the district court still wouldn't issue the injunction. Then we went back to the 10th Circuit, and we won again just this month. This is what we're talking about. This is a process that we have to follow in order to get to the issue of whether the state court can reach onto the reservation and start ordering the tribe to do things there. And the simple answer is that it cannot. And that is also an issue now before the Court of Appeals based upon the appeal from the first order. And I want to just make clear that our basis for saying that is an appeal of right is that we are appealing directly from that first order, which everyone here has agreed. If we appeal from that, that is that's an automatic stay, and we have appealed from that. And the only issue, the only way that will get shot down is if the appellate court says, well, Mr. Broder may have lied to this court in his affidavit, but we're going to forgive that. And I don't expect them to do that. And this court can't predict that. So at this point, it has to stay this case because it's automatically stayed under the state's laws. Thank you.
Mr. Broder.
I would like to briefly respond, Your Honor. I've been practicing law for close to 50 years, and no one has ever before accused me of falsely representing
I'm
any.
going to object to that. That is not relevant or admissible.
No, you raised it. Please don't interrupt Mr. Broder and allow him to respond.
Thank you, Judge. As I was saying, no one has ever before accused me of falsely representing anything, and I certainly have not done that here. Next point I'd like to make. Mr. Rasmussen said a moment ago that everyone here agrees that an appeal to the Court of Appeals as of right results in an automatic stay. Well, no one in this room agrees with that proposition. It may be one that Mr. Rasmussen believes from his incorrect reading of the court rules, but it is not true. This court recognized on November 7 during the first flawed appeal that there was no stay. And this most recent appeal that we received about 45 minutes ago, entitled Appeal of Right in Application for Leave to Appeal, doesn't create an automatic stay either. The Court of Appeals didn't grant one. This court hasn't granted one. And from my brief reading of this document, it's going to be rejected because it's just as flawed as the first appeal. The Court of Appeals in its January 25 order said that the appeal was dismissed and it was denying without prejudice the defendant's right to seek an application for leave to appeal. Apparently that's what it's done, but there's no stay. And this is, from what I can tell, absolute drivel. The defendant also says that this court doesn't have jurisdiction to order the production of documents. Well, I guess in one sense, they're trying to relitigate the discovery matter, which was already argued. But I want to let the court know that if the court were to go through the transaction documents in this case, it will see that the explicit waiver of jurisdiction, a waiver of sovereign immunity and consent to jurisdiction in this court included a consent to be bound by all orders entered by this court. So the notion that somehow we could be in this court and the court could enter a discovery order, but the tribe or the casino doesn't need to comply with it is utter nonsense. I think that's all I have to say, Judge.
All right, thank you. I'll try to address all of these things. First of all, with regard to an appeal and this court's jurisdiction, I was not aware of any recent appeal having been filed other than the one that was dismissed by the Court of Appeals in January. But apparently there has been one filed that's either an appeal by right or, as the Court of Appeals had previously suggested, a delayed application for leave to appeal. But whatever the case may be, there is no stay. There's no automatic stay from filing an appeal by right or a delayed application for leave to appeal. The only time I'm aware that there could be an automatic stay is in the case of governmental immunity and a ruling on that. But that does not cover sovereign immunity in this context. I'm not aware of any stay that would deprive this court of jurisdiction going forward. With regard to the personal service, the court can find that personal service is not required. There is statutory authority for service upon an attorney being sufficient. I believe that the defendant representatives of whom are present today had sufficient notice of this. My procedural issue with what happened before was that this was brought as a motion for contempt. And when no representative of the defendant appeared, I was not able to proceed because there has to be an order to show cause directed to the defendants. Otherwise, the defendants have just failed to appear for a motion hearing that they're not required to appear for anyway. The order to show cause suffices for the notice, and it was properly served on counsel. To the extent that I prevented counsel from completing his argument at the discovery hearing, the reason was this: counsel wasn't interested in arguing their position substantively on providing discovery. Counsel was only interested in repeating an argument that has now been repeated multiple times about sovereign immunity and or subject matter jurisdiction. That was the subject of the original motion for summary disposition. It was the subject of a second motion that was filed that actually verbatim had an exact copy of the brief that had previously been filed and that I had already ruled on and wanted the court to rule on that again. I treated it as a motion for reconsideration, and it raised, literally, because it was a copy of the same brief, the same exact issue that I had already ruled on. And then counsel continued to make this argument about subject matter jurisdiction or sovereign immunity, despite the fact that the court had already ruled on it. So again, the response to the discovery motion was not a response to the discovery deficiency at all. It was yet another repetition of the sovereign immunity argument. Whether you call it sovereign immunity or subject matter jurisdiction, the court's already thoroughly ruled on it. And if there's any doubt, the federal court as well noted that this court ruled on whether you call it sovereign immunity, a motion for summary disposition, or subject matter jurisdiction. This court has already ruled on it. The defendant says that willful conduct is required. I will address that in another minute or two, but actually for civil contempt, willfulness is not required. It's a valid consideration as a factor when the court imposes a sanction, but there is no showing of an intentional willful act for civil contempt. And then with respect to this argument that the tribe is not subject to any of the orders of this court, I'm summarizing, but that's essentially what it is. The tribe entered into a number of contracts with the plaintiff. Those contracts, and there were a number of them, I studied very carefully before the hearing on the motion for summary disposition. And I concluded, as I ruled at the motion for summary disposition, that the tribe had waived sovereign immunity and subjected itself willingly and irrevocably, according to the documents, to the jurisdiction of this court. I know the tribe disagrees with that, and they're entitled to disagree with it, but they're not entitled to then take no appeal, no valid appeal from it, and just refuse to participate in the case because the tribe disagrees with the court's ruling. I've suggested that the ruling could be appealed instead of just refusing to recognize it as the ruling of this court. And instead, the defendants filed an appeal by right, which was, although I gave them some leeway once they had done that, it was a predictable failure because there was no final order, and the proper method would have been an application for leave to appeal. So I gave that opportunity. That's the proper process if you disagree with the court's ruling, but it's not to just say, despite the court's ruling, you can't order us to do anything because of sovereign immunity. The defendants have also said that there's no evidence of contempt here. I have to disagree with that quite strongly. First of all, there's the affidavit of Mr. Broder, who says in his affidavit that the allegations in the motion and brief for order for show cause for contempt of court are true. And those allegations are that the sanctions of $1,500 were not paid as ordered by the court, and the discovery ordered by the court was not provided. So the court does have evidence of contempt in this case. I would further add from the comments of counsel, representative of defendant here today and on other occasions, the alleged contumacious conduct, failure to pay the sanctions and failure to comply with discovery has been all but admitted repeatedly, because the argument is you can't make us do this. So it's not that there's a lack of evidence. There's an abundance of evidence, including the position of the defendant, which is, yeah, we haven't paid the sanctions and we haven't answered the discovery because this court has no jurisdiction. So in any event, I find that there is sufficient evidence, irrefutably and clear and convincingly, that the sanction of $1,500 has not been paid and the discovery has not been answered. Now, these things are clearly willful conduct for all the reasons that I've just described. While they need not be in order to be contempt of court, in this case, they certainly are. From day one, the defendant has maintained the position that this court has no jurisdiction over this matter because the tribe has sovereign immunity. When the court ruled, clearly, again, as I've already said, the defendants disagreed with that ruling, and rather than take a proper course of action to have it tested by the Court of Appeals, they continued to refuse to participate in the case. The witness list, as one example, has not been filed because the defendants, again, have taken the position that this court's ruling is wrong and they just don't have to participate in the case. It goes way back to the scheduling conference when the defendants wouldn't even appear for a scheduling conference because, again, they were of the opinion that this court had no jurisdiction over them. So not only is this entirely willful and calculated, but there is a history throughout this case of adopting this position and refusing to participate. This refusal to participate in the discovery portion of this case has caused prejudice to the plaintiff, as this case has dragged on for quite some time, and the plaintiff has been unable to proceed in any meaningful way because the defendant will not comply with discovery despite even orders of this court. It's also greatly prejudiced the administration of justice for a party to, again, not take a reasonable and lawful course of action to contest a ruling that the party disagrees with, but instead to file clearly improper appeal and to refuse to participate in the meantime, and refuse to acknowledge things such as just filing an appeal doesn't stay in action. So there is great prejudice that has been brought upon this case by the defendant's willful actions. There Also has been not only no effort to timely cure the conduct, but there's been an utter defiance, even up to today, of this court and the authority of this court to oversee the civil action and put in place orders that allow it to proceed, and order things that are existent in all civil actions, such as discovery, scheduling conferences, etc. So again, defiance rather than any effort whatsoever to timely cure the issues in this case. Now, the request for attorney fees, I will agree with the defendant on that there has to be some kind, since they've challenged it, there should be a submission by the plaintiff itemizing their attorney fees in some fashion to allow the court to review that in the face of an objection, which I think I heard today from the defendant. However, with respect to the rest of the sanctions that are requested, I will give the defendant a chance to cure the conduct here, and I will order a fine of, and this, I'm treating this as two separate acts of contempt: the failure to pay the sanctions and the refusal to comply with the discovery order. So with respect to the sanctions, the defendant is fined in the amount of $7,500 that must be paid by the close of business on Friday, unless the sanctions of $1,500 are paid by the close of business on Friday. So it's the defendant's choice to pay the sanction of $1,500 that I previously ordered by the close of business Friday, or else there will be a fine in addition to that sanction of $7,500 for contempt. With regard to the refusal to answer the discovery, the defendant has 14 days from today. So by the close of business in 14 days from today, which would be February 23rd, if the defendant has not provided complete, non-objected, and full answers to the discovery requests, then a fine of $7,500 is imposed for the contempt. And then I'm taking the attorney fees, which are a valid element of sanctions as well, under advisement for an itemization. And unless there's something further for the record, that will conclude our hearing.
Yes, Your Honor. We want to note for exception and note that the court misstated many of our arguments, particularly with regard to the application of the tribe's statutes. This is not a sovereign immunity issue. This is a jurisdictional issue regarding this court's authority to order somebody to do things in a different jurisdiction with a tribe. That has to be done that has to go through the tribe's laws. That was our argument. The court is trying to change it into a sovereign immunity issue, which it was not presented as, and is not what we were arguing. Then the other thing is just one other thing is the court seems to be saying that it has ruled on jurisdiction, but the actual orders from the court specifically refused to rule on jurisdiction. If the court had ruled on jurisdiction, and this is what we say in our petition for appeal and our appeal of right, is that if the court had ruled on jurisdiction one way or the other, up or down, then we would have been able to take all the preliminary issues up in a single appeal. And we view it, and I know the court apparently doesn't, we view that as being respectful to the court and to the Court of Appeals, because the way that you do that is if the court does rules on a procedural ground, rather than wasting the appellate court's time on a issue that could be kicked on a procedural issue, you cure that and ask for the other order. And so if the court had done what it said today, I think it was saying today, and what the US court apparently viewed, which is that the court was effectively saying it had decided jurisdiction. If the court had actually said, I am deciding jurisdiction, we would have been able to go up on appeal on the first appeal. That is a big part of why we're asking for appeal now, is we feel like we were trying to be respectful of the courts by getting the ruling on all of those issues before going up on appeal. That is what we standardly do, and that is what we did in this case. It is not trying to be disrespectful of this court, it's trying to be respectful of the appellate court.